One of my colleagues suggested that it was a bit unfair because I got an opportunity on Wednesday to make a presentation on a model of attorney-conducted voir dire, which I tried to do in a balanced way. And then today I get to sum up. I got to present my evidence on Wednesday and do my summation today. But I'm really not thinking about it. What I am thinking about in the context of this conference and the opportunity it affords us as a justice system to improve our jury selection process is the obvious analogy, Chief, to criminal justice reform. The joint committee paralleling the committee that the Chief is about to convene in the aftermath of this conference, the legislative action that went along with that joint committee recommendation, which was consensus, unanimous on all the points involved, resulted in the elimination of cash bail and the creation of a model of pretrial release, which unfortunately has not been taken up by as many jurisdictions in this country as probably should be, because it is, as far as I'm concerned, the most fair system that you could devise to decide who should be in jail before trial and who should be on pretrial release. I think there were 4 lessons to be learned from that experience that can be applied directly to what we're about to undertake with jury selection. The first is there has to be an acknowledgement by all that the current system is flawed. Now, you may not all agree as to why it's flawed, but absent some acknowledgement that we need change, an endeavor like this will fail. In the context of criminal justice reform, my position, my constituency said, it's not right, it's flawed. You have poor people in jail on minor charges because they can't make $1,000 bail, and that's not right. And law enforcement looked at it and said, you shouldn't have people who are violent offenders who've committed serious crimes or accused of serious crimes who can buy their way out of jail because they have resources. But everybody agreed that the system was flawed, and the same concept applies here. Second, I think sometimes, not always, change is accomplished by consensus, a point Andrew, I think, properly just made. Not always, but sometimes. And this is one of those times, at least in my view. Third, CJR came about because the stakeholders were willing to compromise. The compromise of the defense of the public defender's office was to say that a trade-off of preventive detention is worth it if it gets our clients out of jail who are in there strictly because they're poor, even if they're charged with very minor offenses. And fourth, and maybe this is the most important point that I want to make this morning, is that it worked because we didn't just tinker around the edges. We didn't just do like some jurisdictions and say, okay, let's eliminate cash bail for misdemeanors, but let's keep it in place for felonies. We didn't try to do minor fixes. We had the foresight to say the system must be overhauled and it must be done right and it must be done at once. And on January 1st, 2017, at the stroke of midnight, New Jersey's criminal justice system changed at that moment for the better, because we didn't make minor changes. We took on the issue head on and we came together and we changed it for the better. So the question is, can we replicate that model now and improve our system of jury selection in this state? And I'm here to say that I believe the answer to that question is yes. There is a blueprint. And what is that blueprint? Well, I made a list of things that are on that blueprint, many of which were alluded to by the Attorney General moments ago. We can expand our source list to make more people part of the process. We can pay more money to jurors to address that obvious concern. We can permit people who've been convicted of crimes to participate in the process. We can adopt a model of attorney-conducted voir dire, not necessarily the same one as I demonstrated on Wednesday, but something similar, or maybe something very much like that, because that system has been shown to be better at detecting implicit bias among jurors. We can establish a more liberal granting of cause challenges. We can tie that to a new standard, perhaps a more objective standard, where a judge is not necessarily tied to the subjective statement of a juror that, notwithstanding all my personal experiences that when on the face of it appear to make the juror biased, I can nevertheless be fair and impartial. An objective standard that requires a judge to look at this juror's answers during the voir dire and say, would a reasonable person think this is an unbiased juror? We can change the Batson-Gilmore standard, as alluded to by the chief in the Andujar opinion. We can reduce the number of peremptory challenges in criminal cases if we do all that. In criminal cases, not necessarily in civil, but it's not my domain. I represent people charged with crimes. And we can create a more efficient system where it doesn't take as long to pick the jury. Because everyone in this room knows that there are courtrooms in this state where a judge could spend days picking a jury, and there's other courtrooms in the state where a judge can do it in 1 or 2 days. And that demonstration I did the other day, they picked a jury in a serious case in 2 hours and 45 minutes, and it was fairer than most processes in this country. Not every stakeholder is coming to this with the same agenda. It's not to say anything out of line, to say judges are concerned about how long it takes to pick juries and how many peremptory challenges the lawyers have. That's no secret. I understand that. Trial lawyers want to protect their peremptories and have a more expansive voir dire process. I get that. But this blueprint can address all of those concerns in a way that's fair and makes our system better. Our Attorney General's remarks speak for themselves. We have a number of other speakers. We have the County Prosecutor Association, Esther Suarez is going to speak. I hope we hear a same amount of openness to real reform. There are multiple bar associations and other constituencies that are part of this process. I hope they come to this with the same open-mindedness. There will be representatives of the legislature and the governor's office in the committee work. And I hope they come with the same openness. So in conclusion, let me just say that the case for this blueprint is a compelling one. The national trend towards attorney-conducted voir dire is based on the fact that it is a better system to detect bias among prospective jurors. It takes out of the system what many of us as trial attorneys believe are the efforts of judges to, quote, rehabilitate jurors whose answers on the face of them should disqualify them from service. So the move towards attorney-conducted voir dire and a reduction in peremptory challenges, they're inextricably tied together. And more liberal granting of for-cause challenges is also tied to the same reduction in peremptory challenges. And every other proposal in my blueprint, and that's been featured by speakers in this conference, they all enhance the diversity of our jury pool, and they lead to a fair cross-section of the community hearing the cases against our citizens. You know, one of the benefits of having a statewide public defender system and a statute that says literally that I'm the attorney of record for every single person represented by this office who's determined indigent, which is somewhere in the 90% of everybody charged with a crime in this state, is that we can speak with one voice and we can take one position. And that made a difference in CJR, and it can make a difference now. Back in 2005, I authored myself, I wrote the dissent to the report that Judge Lisa spoke about on Wednesday that came out of the Supreme Court Committee on Voir dire and Jury Selection between roughly like 2003 and 2005. And my dissent was to the recommendation that peremptory challenges be reduced in criminal cases. It's 16 years later, and this is what in my view is different. While we did enhance the voir dire to some extent by that protocol that went into place in 2006, 16 years later, we know that it's not working the way it should. We know it's not. And the Andujar situation is a perfect example of that. And that's part of the reason we're here, because the chief wrote in that opinion that he was going to convene this conference. And so what we've learned now is that this judge-dominated method of voir dire is not the best way to do it. It's not the fairest way to do it. It doesn't elicit the same kind of open and honest answers from jurors. And there is a better way. So if we are serious in this endeavor, we will overhaul this system. We will do it right. And in so doing, we will be certain to protect the right of every citizen in this country who's accused of a crime to a fair trial in front of a jury that represents a fair cross-section of the community. Thank you.